Thank you.
We're live.
Good afternoon. It is March the 14th, 2022. It's Pi Day. And welcome to the House Judiciary Committee's voting session. We have a large number of bills that we're going to be dealing with today. And we're going to start with House Bill 33. This is Delegate Shetty's bill. Delegate Shetty, can you please tell the committee what the bill does?
Yes, Mr. Chair. Good afternoon, colleagues. This bill would essentially put in place a process so that we are removing the codified controlled drug schedule list from Maryland code and instead putting in place a process that allows Maryland to align our scheduled drug list with the federal list, with some exceptions when the Department of Health or state feels otherwise. What we've been doing instead is we're waiting every year. We have to do it by statute. We haven't done it in a couple of years, so we're out of compliance, and that puts pressure both for patients as well as for our enforcement arm, our law enforcement arm. So this future proofs our efforts here in the General Assembly.
All right. First, is there a motion on the bill?
Move favorable.
Motion for a favorable. Is there a second?
Second.
All right. Now, are there any questions or any comments on the bill? We'll start with Delegate Grammer.
Thank you, Mr. Chair. Just so to be clear here, for example, if the federal government moved marijuana off Schedule 1, so would we.
Correct.
Okay, thank you.
Any further questions? Okay, seeing no further questions, we'll go ahead with roll call, sorry. And I think we have enough to do that. The Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Arakan. She's excused. I think she's in HGO. Bartlett.
Yes.
Carden.
Yes.
Conaway.
Yes.
Cox.
Yes.
Crutchfield.
Yes.
Davis.
Yes.
Juanica Fisher.
Yes.
Grammer.
Yes.
Howell.
Yes.
Rachel Jones.
Yes.
Lopez.
Yes.
McComas.
Yes.
Munoz.
Yes.
Shetty.
Yes.
Cham.
Yes.
Tolles.
Yes.
Williams.
Yes.
It's 20. Okay, so that is going to the floor. We're now going to House Bill 83. There are amendments to House Bill 83, and this is legislation that the former vice chair of the committee has brought several times. I think it's probably hurtling towards yet another conference committee, but let's see where we're going to stand at least. There are amendments. 973229 is the amendment that was put together by Delegate Shetty. Delegate Shetty, can you describe what the amendment does? And in so doing, describe then what the bill would do as amendment.
Yes, sir. Hello again, colleagues. So this amendment that I worked on with Chair Atterbury and her support, what it does is and with the bill as amended and passed unanimously out of subcommittee, what it does is it makes the minimum age of marriage here in Maryland 17, whether or not you are pregnant. It maintains the judicial review component, which was present as part of the original legislation. The judicial review component is very important. It ensures that there is an independent party, a judge, namely, who can individually assess whether there is coercion or duress occurring with the minor getting married. It restores or maintains the 4-year age gap requirement, reflecting our current statutory rape laws, which already have a 4-year age gap requirement. Trying to think of what else. Oh, yes. As you'll recall, colleagues, from our numerous hearings over the years over this bill, one of the key issues for young people when they are getting married is they do not have the capacity to contract, which means they also do not have the capacity to exit a marriage without parental consent, even after they have become married, unless they are emancipated, which is why the original provision of the bill required full emancipation so that the young person could have that as an option in the event that it were needed. What the bill as amended does is it does not require full emancipation. However, what it does do is it grants the ability of the minor to exit the marriage in the event that that's needed. And it also gives them the ability to contract, so whether or not they are married. This is really important because it ensures that the young person has a place to live, is able to sign a lease, open a bank account, just do basic tasks to take care of themselves as if they were already the age of majority. And so that is what the bill as amended would do. And I'm happy to take questions.
Move the amendment.
Let's do that first. So there's a motion on the amendment. Is there a second on the amendment?
Second.
All right, motion and a second on the amendment. Now we'll take questions. We'll go to Delegate Carden first, then Delegate McCombs.
Thanks for the great work, Delegate Shetty, on trying to find some compromise. If we pass this and this passes as we pass it, and I'm going to give you a hypothetical: a young lady gets married, decides she has a kid, decides the marriage isn't right. She has the ability to contract to get an apartment with her baby, even though she's a minor because of the way we've drafted it. But is she going to be able to make decisions as a minor on behalf of the child because she's not 18 yet? And if not, is it something we should consider?
That's a good question. I don't know that her rights as a parent are affected by this bill either way. I think, we are through the bill as amended, we are giving the minor the ability to contract. And so she would be able to, for example, get health insurance, enroll in health insurance. She would be able to get a bank account so she could pay bills, pay for daycare, et cetera. So I don't know if there's a specific legal right that you're concerned about that may not be included.
Yeah, I'm wondering, like, if she wants to enroll in school or in some sort of, something that requires parental consent. And I'm just, I guess it sounds like it's probably covered, or this isn't really.
I think it would be, because we're giving in this hypothetical scenario, the young woman the ability to contract. So enrolling in school would be a contract. I think other basic abilities.
Setting up a 529 plan. I mean, like, I'm thinking like all the different things that usually you need somebody who's at least 18 to be able to do it.
That's a good question. I don't know whether it's impacted either way. I would say that, a 529 plan certainly is something that, is beneficial to start as soon as possible. But we're talking about the hypothetical 17-year-old.
I understand. I just want to make sure we're not denying them something that we are, in the end, we're going to look in retrospect and say, oops, we forgot. So that's all.
Right. No, I appreciate the question. I think that's a really important one. But I believe that under the contract provision, we are likely taking care of that. Thank you.
Delegate McComas.
Thank you, Mr. Chair. Just briefly, on page 2, 4 in parentheses, notify all the petitioner's living parents, guardians, or legal custodians of the case and the right to support or oppose the petition if the court is able to locate all of the petitioner's living parents, guardians, or legal custodians. My concern is with the all. The problem is you might not be able to get all the parents, or, for some reason there's a divorce or something, or they're in, Alaska or Antarctica or something. So I just wondered if there was some way to, because the all, I think, is pretty much set in stone. So I was wondering if that could be modified, if practical, all or something, or, just something that you don't have to have all if you can't get all.
Yeah, I appreciate the question. I don't have the language up in front of me at the moment, but I think that you read a clause in there that might potentially create that type of modifying factor, that if the court is able to locate, seems to me to read that it would potentially create that sort of safeguard for scenarios in which, like in the hypothetical you presented, delegate, the guardian is in Alaska or Antarctica or something. But in the case of, my own childhood, not that I was in this scenario specifically, but I had an estranged parent, so the court would never have been able to locate him. So that would have, been covered under this type of language, I suspect. But I understand your concern. Yeah.
So you don't think the all hurts the able?
I do not, but I understand your concern and your read of it.
Okay.
Are there further questions for Delegate Shetty on the amendment? All right, we're on the amendment then. All in favor of the amendment, please raise your hands. Delegates McComas, Munoz, Shoemaker, Davis, Williams, Lopez, Anderson, Cox, Cham, Moon, Jones, Bartlett, Crutchfield, Shetty, Howell, Carden, Grammer, Davis. Anyone opposed to the amendment? I think I saw Tolls's hand, but anyone opposed to the amendment? Seeing none.
That's for the amendment, Mr. Chair. Thank
All
you.
right. Thank you, Delegate Tolles. Then the amendment is adopted. We're on the bill as amended. Could I have a motion on the bill?
Move the bill as amended.
Favorably.
Is it favorable and in multiple seconds? So we're on the bill favorable as amended. Are there further comments or discussion on the bill as amended? All right, then we'll go to a roll call. The Vice Chair.
Yes.
Shoemaker.
No.
Anderson.
Yes.
Arakan.
Yes.
Bartlett.
Yes.
Carden.
Yes.
Conaway.
Yeah.
Cox.
Yes.
Crutchfield.
Yes.
Davis.
Yes.
Juanita Fisher.
Yes.
Grammer.
No.
Howell.
Yes.
Rachel Jones.
Yes.
Lopez.
Yes.
McComas.
Yes.
Munoz.
Yes.
Shetty.
Yes.
Cham.
Yes.
Tolles.
Yes.
Williams.
Yes.
19-2. Okay, it's favorable with an amendment. That will be heading to the floor. All right, next is House Bill 129, which I don't think went through subcommittee, but has a substantial amendment. I believe a substantial amendment, which is over here. It's an amendment. You should have a interlineated copy of the bill in your packet. The amendment number at the very, very top is 123927. Why don't we ask Lauren, or no, let's not ask Lauren, let's ask Claire. Let's ask Claire if you could tell us what the amendments do and what the bill does as amended. And, oh, that's right, HGO is the primary on this bill. So we are just secondary on it here today. Claire, can you give us an overview of the bill as amended?
Yes. Sorry. Sorry, I'm just scrolling down. Okay. The amendments just changed the language somewhat as the bill was introduced. It required the department, when awarding grants for this program, to require that the proposals contain response standards that minimize law enforcement interaction for individuals in crisis. And this amendment is just tweaking that language to instead say the standards must prioritize mobile crisis units over law enforcement when responding to individuals in crisis. And that's about it.
Okay, so
Oh, and they also require training at the end of the reprint. That it just requires that the policies have to provide for training for the staff.
each public safety answering point shall develop a written policy on the procedures to be followed by the public safety answering point when a call is received that involves an individual suffering an active mental health crisis. That is what's required. And the policy has to include the procedures to triage a call. I know I'm reading the bill, but just for everybody at home, the resources that are available for dispatch, the procedures for making a dispatch decision, and the training for applicable staff on implementing the procedures. All right. Are there questions regarding, could I have a motion related?
Move the amendments.
All right. Is there a second on the amendment?
Second.
Thank you very much. All right. So now we're on the amendments. Any discussion on the amendment to 129? Seeing none. All in favor of the amendment to House Bill 129, please raise your hands. That is Munoz, McComas, Cardin, Lopez, Williams, Davis, Shoemaker, Grammer, Fisher, Jones, Moon, Cham, Cox, Shetty, Crutchfield, Bartlett, Anderson, Howell, Tolles. Anyone opposed to the amendment? Seeing none. All right. Amendment's adopted. We're on the bill. There's a motion for a favorable. Is there a second?
Second.
And a second. All right, we're on discussion on the bill as amended. Is there any further? Again, we are second to HGO. They've already voted it out. So we'll go to the vice chair, and then we'll go to Delegate McComas. Vice chair.
Thank you, Mr. Chair. I just wanted to clarify. I believe this was unanimous in HGO. Is that correct?
Tell you because it's right over here.
I don't think it was unanimous.
It was. It was not.
Okay.
And
Well, this would be interesting then.
it was not, and it appears that it was partisan in its voting breakdown.
Oh, holy.
One moment, please. Voting in favor were Pendergrass, Pena Melnick, Robin Lewis, Kelly Kerr, Bagnall, Belcastro, Baladari, Carr, Cullison, Hill, Johnson, Rosenberg, Sample Hughes, Karen Young, Landis, and Kaiser. Voting against Morgan, Riley, Kipke, Krebs, Chisholm, Saab, and Shalaga.
Oh, interesting. Okay. Thank you, Mr. Chair.
You're very welcome. Delegate McComas.
My question is, my concern is if a person is having a mental crisis, but they also have access to arms or knives or a bazooka, that kind of changes the whole character of the interaction. And I realize we're going to have regulations and everything, but my concern is that, there's two things here. There's the public safety, and then there's the safety of the person going through the mental health crisis. And if, depending if they're psychotic, they could be violent. And I just not sure how that's going to interact. And I kind of suspect that may be why my colleagues that are on the committee voted against it in HGO, but I'm speculating at that point.
We'll go to the vice chair, who I think wants to respond, and then there are more people who are popping up. Delegate Moon.
Thank you, Mr. Chair. I hate to get a second bite on this one, but I'm just puzzled by the votes here. And so I'm noting, I'm looking online and looking at the Senate. It looks like the Senate moved this bill too. And unless I'm reading it wrong, it was unanimous in the Senate, both in committee and on the floor.
I guess to your point, Delegate McComas, I guess one of the substantive parts of the bill goes to saying that they have to adopt a written policy for the procedures to be followed. So if they have a bazooka or a knife or a BB gun or some level of weapon, I think that would be addressed in the procedures that they would follow if somebody was having a mental health emergency, in determining whether or not to send law enforcement there. But that would be determined in that policy statement. So, and it's not necessarily determined here. But now there are more questions. So let's go to Delegate Erican and then go from there.
Thanks, Mr. Chair. So I think I see what the bill's trying to get at. Like, I don't think any of us want to see a situation where we have like an autistic child or something like this, where, we're putting them at more risk, right? If people don't understand the situation that they're going into. But I do worry. I mean, if we're just sort of saying, make up the rules, we're just sort of outsourcing that. And we're not the body considering what the rules should actually be. How are we going to make sure that if, for example, someone who is suffering from a mental health crisis, but didn't, they don't know at the grocery store where the person is having a meltdown, if the person is armed or dangerous, how would they know? So we send like a social worker in, and then they show up and the guy's melting down and has a concealed firearm or something. Or, I mean, that to me is, and can you imagine the ripple effect? I mean, if only one of these social workers is murdered because of this kind of policy, good luck ever hiring them again, because they're not going to feel like we protected them. So
I guess my broader feeling here, though, is if the point of the bill is to require the local agencies to just kind of to create almost a flow chart of, so we've got this call, and this is what we're going to do next. Here's what the 911 here's the information the 911 operator needs to collect. And if what they collect is there's a person with a gun in the middle of the shopping center, okay, well, that's the information that they have, and so they have to respond appropriately. If it's a person standing in the middle of Webster Street and screaming at the moon, then they might respond a different way. And let me just say, I will admonish myself for necessarily characterizing it that way, but they get a lot of different calls. And when you talk about mental health issues, it's not just somebody who is maybe demonstrably, acting out either. So I think the danger with trying to second guess all of those, I think there's a broader acceptance that I think there is, that we would prefer, if somebody is in a mental health crisis, to try and get services there to the extent that we can. It's a question of having those local agencies be responsible enough to kind of work through, to run all the traps. And I think that's basically what we're asking to do here. So Delegate Erican, I'll go back to you, and then I'll all of a sudden, a lot of people want to talk about this. So we'll
Yeah, I
go
mean,
through that.
that makes sense. I would love to see what a flow chart would look like so we can kind of get an idea for it. Cause I think the goal is laudable for sure, to try and prevent people with mental health crisis from, meeting an unnecessarily stringent and harmful reaction. But also I worry if we don't know if somebody is armed and they seem like they may not be, there's no visible weapons on them, they could end up getting the wrong response and it could really deteriorate quickly. And then people who are really just trying to help, like some of our crime people down the city that try to bust up crime, and they just go out there and they talk to people and they try to, talk them off ledges. We've had some of those people killed recently. So that's in the back of my mind, trying to think about the kind of people that they're going to show up to the scene and what could happen to them if we don't protect them.
Can't you argue and I'm sorry, now I'm going back and forth here a little bit, but can't you argue that that's kind of the problem that we have right now? That we don't have clear procedures in place to kind of start to figure out those flow charts. And I don't know that even that's entirely true. I don't know that it's necessarily that focused on people who are in a mental health crisis, I guess. But there are procedures for a lot of different situations. This is just asking them to create those procedures for situations for people who are in that crisis, and begin to look at it through that lens. I don't know that this bill necessarily means that we're going to send a social worker to every single situation. It might mean that, like here, or through my work, familiar with, and we've all become familiar with the crisis intervention team here in Anne Arundel County and a couple other places across the state. They have a set process where they go out with people to evaluate those situations and provide the appropriate response. And since I've talked long enough, there are now 6 other people who want to talk. So been nice talking to you, Delegate Arikan. Let's go now to Delegate Grammer.
Thank you, Mr. Chair. So I just wanted to talk through some of the points I think maybe I have with the bill, and put it out there for discussion. So to start off, in the Senate, they either kill your bill or it's unanimous. And that's pretty much the standard. But in regard to this bill, so it reminds me of that discussion we were having with the public offenders. And they said, we don't want to have youth involved with cops or judges or the juvenile system because the statistics show anytime they have an interaction, that they're more likely to recede. And we were like, I said, well, who do you want them to interact with? And they were kind of like, I don't know. So my problem with this specifically is you get the feeling that we're putting a bureaucracy in place and trying to figure out who should be sent out for these kind of calls. In my community, in my county, from what I've seen, the law enforcement most frequently knows the streets, they know the people, they know the communities. And if you've ever called 911, you better get a coffee at this point because you're going through like a 5-minute questionnaire. And I feel that this kind of thing is just going to kind of create that upfront bureaucracy as they try to figure out, who should we send out as opposed to getting the officer there. And in my experience, the officers, they do a good job of triaging. And I like that what I feel like the bill is trying to do is get us to divert people away from like working with law enforcement and towards services. But I just don't think that should be done at a high level. I think we should, when a person calls, they should get the information they have and get someone out as quickly as they can if someone needs to go out. But I think the frontline law enforcement in my community do a good job of that. And I just feel we're creating a bit of a bureaucracy here.
Delegate Bartlett.
Thank you, Mr. Chair. I wanted to go after you because you mentioned the great Anne Arundel County. But anyway, it's still applicable, right, Delegate Munoz? All right. So as you all know, Anne Arundel County has an excellent crisis response team, and they are law enforcement officers. Well, some of them are. they also have social workers. So they tend to come out both as a law enforcement officer, and they have social workers, and they have bilingual individuals. So it's my reading of the bill that we are talking about a program, and that we're talking about the Behavioral Health Crisis Response Grant Program, and asking for priority with respect to the training, and with respect to giving priority to certain, I guess, authorities that actually will train and put behavioral health above law enforcement in the sense of coming out. I didn't read it as it's who's going to get called all the time. I just saw it as create this program and get this funding because, you know, it's worked so well in Anne Arundel County. Well, not quite that part, but the point is there, that it has worked well in Anne Arundel County, being international award winners and all. And I think that that's the purpose of the bill.
Right. Now, after
Did I
that-
mention Anne Arundel County? No.
Yeah, okay. After that blatant Anne Arundel County boosterism, we'll now go to Delegate Cham.
Thank you, Mr. Chair. I was busy trying to read and catch up on the bill. I can see the intent of it. I can embrace the intent of the bill. It's very important with regard to what we're trying to do and who we're trying to help. But I would be cautious, because I think some of the unintended potential dangers of this bill is if whoever this crisis team is going to be responding to a person in crisis, most often working with people with disabilities, the interventions that you use are very individualized and they're very personalized. And if you don't know that individual, you're just kind of going in and randomly trying different interventions to bring the crisis down or de-escalate the person. And so much so, the best practices and interventions that you use may escalate the behavior or the person in crisis. So that's kind of my challenge in really seeing this bill and embracing it in its totality. Although I see the intent of it, I think the bill itself and the way that it's written probably isn't going to help the greater good of people who are in crisis, but it might cause some further harm. So I'll be voting no on this. Thank you.
Delegate Munoz, who apparently is from Anne Arundel County.
I am, just a little bit. And I keep putting my hand down because I don't usually speak up on these things. But since I have worked with the Anne Arundel County Crisis Response Team, and I've been on the mobile crisis unit, and I've been out all across the county, I figured I would just say a couple of things. So I totally agree with Delegate Bartlett. Like, this is there's a great intent behind this bill. But even with the amendment, I'm concerned that this is going to kind of put the cart before the horse a little bit. And speaking from, experience with the Anne Arundel County's version of this, which is, like the delegate said, internationally award winning, the police. Bless you.
Excuse me.
Bless you, Delegate Cardin.
The police and the counselors work so closely hand in hand. And the way it works is the police get called out and then they call the crisis unit. And the crisis unit, at least when I was there, is a bunch of people like me in polo shirts, who have graduate degrees in counseling or social work. They're graduate students. Personally, I have a black belt, so just throwing that out there, but most people have absolutely no experience with self-defense, combat, any of that kind of stuff, nothing like what the police have. So the police usually go first and assess the situation. And then if it's a mental health related situation that's safe for us to participate in, they'll call us. But then they stay there. And the piece about minimizing interaction with law enforcement, they're really just there to protect everyone and keep everyone safe. And I think like Delegate Erican said, like, I mean, I've been out, you guys, for suicides, domestic violence, murders, people with severe mental health issues who are very volatile and very dangerous, and they need the mental health care and counseling in those crisis moments, but they also need protection for themselves, others, and the counselors. I've had to go into high schools where high school students were a danger to themselves and everyone around them. And counselors can only do so much, but to get that particular child to the hospital, like the police had to do that for us, so that we could get that child, the proper care. So that's why I'm concerned that this bill has like some really good intentions, but it's going to make it a lot more dangerous for crisis intervention counselors and people in the community. Because if you send counselors out and anyone who's ever worked in mental health knows how volatile it can be and how quickly things can change, especially when you're dealing with things like substance abuse and mental health illness. And so I just wanted to share a few kind of personal experiences and thoughts and why this bill concerns me. Even though it has good intentions, I think it could have really dangerous repercussions. We don't have enough crisis intervention counselors. It's actually the highest burnout rate of any of the mental health fields. And so we need more, not less. And so if they have less protection and they feel less safe, there's probably going to be less people out doing it in the community. So.
For the record, did Delegate Munoz, did you just indicate that you have a black belt? She does, everyone.
Yeah, just throwing that out.
Just putting that out there. All right. Delegate Cox, then Lopez, then Delegate Juanita Fisher. Delegate Cox.
Thank you, Mr. Chair. My concern is along the lines of tort liability. Wondering, when you do these constitutional torts, if there's a policy or procedure that's willfully not followed, it immediately provides the attorneys litigating some ground to go after the cops or the chief or the department. That's just my concern. I didn't know if there's any evidence about that we learned of, or if the FOP or sheriffs had anything about that liability aspect. But it came to mind also because of the recent knife incident. You might have seen the news, I think it was yesterday, where the police were exonerated for shooting the girl that had the knife that while she was attacking her friend. I think she had a mental health incident, but my concern with that would be, although it was clearly ruled by the Attorney General to not be at fault for the police officer, apparently if we had a per se statutory requirement for a policy that in the midst of a emergency was not followed exactly, I'm just a little nervous that it might automatically provide some grounds for litigation. That's my concern against police officers, and we already have a problem retaining officers here in the state, so that would be my concern.
Delegate Lopez.
Thank you, Mr. Chair. I wanted to share with the committee that I plan on supporting this legislation. And the reason is because, as I'm looking over all the materials that have given to us, I realized that, if this had been put in place, perhaps there would have been a life that was saved in my district. In the last calendar year, there were 2 African-American men who were shot by police in my district. One of them was a young man who was experiencing a mental health crisis. Some of you have heard this story. He was driving through a McDonald's drive-through and was having an acute stress response when he was paying for his meal and thought that he should have gotten his food at the same time. It's a man who's experiencing a mental health crisis in a very pedestrian, mundane, everyday type of experience. And the situation was escalated, and we know how it was resolved. And when I look at this workflow, I see a lot of different opportunities for there would have been intervention. And so I don't think, to some of the arguments that have been made here, I don't think that if the police, emergency response had been called, it looks like there's still law enforcement who has a specialization in mental health that could have responded here. Or perhaps there is a behavioral health specialists who could come out. And so I think one of the tasks of our committee is to understand when there's a public health risk and when there's a public safety risk. And this workflow, and specifically this bill, helps us get to that place. So I'm excited to be in support of this bill.
Delegate Winika Fisher.
Moved previous question.
Motion for the previous question. All in favor of moving the previous question, please raise your hands. Anybody opposed? No, nobody wants to talk anymore. That's fine. We're on the bill as amended. We've had discussion and we are going to go again. We are second to HGO here, so we're secondary anyway. We're going to go to a roll call. The vice chair.
Yeah.
Shoemaker.
No.
Anderson.
Yes.
Arakan.
No.
Bartlett. Bartlett on 129.
And my vote is yes. I'm sorry, Mr. Chair.
That's right. Carden.
Yes.
Conaway.
Yeah.
I'm sorry, repeat that, Delegate Conaway?
Yes.
Okay, thank you. Delegate Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Winika Fisher,
Yes.
Grammer,
No.
Howell,
Yes.
Rachel Jones. She's away from her desk. Lopez,
Yes.
McComas,
No.
Munoz,
No.
Shetty,
Yes.
Cham,
No.
Tolles,
Yes.
Williams.
Yes.
I see 14 to 6. 7. Wait a minute. Nope, I see 13 to 7. Yeah, that's right. All right, so there is our secondary on that bill. Delegate Carden, I'm understanding that you want to hang on to House Bill 176.
Yeah, I think we're going to probably have voting sessions again later in the week, right? Tomorrow.
Oh, I'm pretty sure we will. Yeah.
I'm just going to ask, just to out of caution, to make sure that all my advocates are okay, the ones for and against and everybody. So I'm going to hold it and make sure the amendment is perfect.
Yeah, I would say the amendment, as I had thought it was going to be, would seek to exempt
right, and that's
landlord
what
tenant matters.
the amendment it attempts to, and according to the bill drafter, we believe it does, but we're just checking with everybody to make sure that in fact it does, because there was a question of whether it also covers ejectments, summary ejectments, and unlawful detainers. We just want to make sure it covers them as well. So,
Okay. All right, then we'll hold on to that all the way till tomorrow. Let's go to 225. This is Delegate Young's bill. I have here that there is an amendment, but I don't have an amendment. I'm not sure there is an amendment.
I don't believe there is an amendment.
No, I don't believe there's an amendment either. Council, can we just put on the record what the bill does?
Sure. It requires an assistant state's attorney to meet with a victim of sexually assaultive behavior at the request of the victim after a decision by the state's attorney not to file a charging document against an alleged suspect or to dismiss charges against an alleged suspect.
Okay, can I have a motion?
Favorable.
Get to questions. There's a motion for a favorable second. All right. Now we will go to questions. And Delegate Cox, let me just ask very quickly. Do you have another bill hearing in another committee, Delegate Cox, or are you bouncing back and forth? Or are you done with that?
Yes,
Okay.
I have another hearing. I'm heading out in a moment.
That's fine. I just wanted to put that out there in case we have to
Thank you.
call you excused. That's why. All right, Delegate Cox, go ahead on 225.
I recalled the state's attorneys were not supportive of the current posture of this bill. Is that still true?
They came in unfavorable and it's not amended. So I suspect that's probably true. Yes.
Thanks.
All right. Delegate Arakan.
Yeah, I just wanted to touch on their testimony a little bit to make sure that I remembered it correctly. I think the problem they had was that the files can stay open for a very, 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 very long time. And so that decision might not actually be made because they keep it open until, in case new evidence comes forward. They don't always make a call. I mean, Mr. Chair, you'd know better than I how that process looks, but I think that was the reason why there was so much unfavorable testimony from the State's Attorneys Association, because they're just not sure how they would comply with it, considering they usually don't sort of close a file. They leave it open until it expires, right? So that they can, and now that's forever, right? We've taken away the statute of limitations. So I think that was the concern, if I'm right.
I think that's a concern that was raised. I know we passed this bill last year as well. I think the argument is, and many counties, state's attorney's offices have victim advocates who work with the victims of especially serious crimes like this, who would be in contact with them and conversation with them. I think, if they never make the decision, if they never make the decision to not go forward, I'm feeling like I'm entering a double negative hell here a little bit. If they decide not to file a charging document, to your point, they may never actually make that decision, in which case nothing in the bill gets triggered. So it kind of, I mean, it's a little bit of, if they never decide to dismiss charges against at some point they would have to decide. If they brought charges, they'd have to decide whether or not to dismiss charges. But if they were doing that, then there would be a victim witness advocate there in almost every case who's going to be able to convey that information to them right away. I guess the broader concern, from what I understood, what the delegate was talking about with the bill, is more those situations where that fall into kind of, they don't go on forever, but they also don't get charged right away. And so when, it's whether they make a decision not to go forward once and for all, that requires that additional notice to the victim. Delegate Cardin, then Delegate Bartlett.
Thank you, Mr. Chair. Maybe the staff person can help me with understanding. This doesn't require the state's attorney, it just requires a member of the state's attorney's office, like an assistant state's attorney, to communicate with the victim to make sure that they know what's happening. Is that fair to say?
That's correct. It's the assistant state's attorney with knowledge of the case.
It would seem to me, I mean, just being in court all the time and being very frustrated, sometimes with defense attorneys who I'm trying to work with, and sometimes with state's attorneys who I'm often trying to work with, if you could just get sometimes it's painful to hear for the victim, but to understand that either there's a weakness in the case or that there's a rationale or reason why we're not proceeding. It seems to me like that would just help create closure and it might be hard to rip off the Band-Aid, but it would make everybody's lives a lot more predictable and stable. So I think this is a good bill, even though it may be a little painful to set up the policy to do it.
Delegate Bartlett.
I'm going to lower my hand, and I'm assuming that you might be ready for a vote.
Move to previous question.
Oh, wow. Okay, you got out in front of Delegate Fisher there, apparently. All right, that's fine. It's not, there's a motion for a favorable and it was seconded already. So we're on the bill. Seeing no
favorable
discussion. I think we did it. We got all that. So we're good. We're there. We're getting there, swear. All right, so we'll go with the roll call. The vice chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican, Erican, come back. Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yeah.
Cox. He was excused. He had to go to HGO. Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones.
Yes, and Mr. Chair, is it too late for the record? I had stepped away on the last bill. I wanted to
We'll,
vote.
we'll let you vote yes on the, on 129 as well, because I saw you stepped away there.
Thank you.
Lopez,
Yes.
McComas,
No.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
Erican,
Remind me again. Oh, how did
224.
how did my minority leader vote? Yes. Okay, I'm a yes. Oh wait, he says no. Okay, I'm a no. Oh, Munoz is messing with me. Sorry.
Yeah, no, interestingly, that you are asking unhelpful questions if you're looking for the results on the Republican side of the equation right now, because you're the majority
He just
leader
likes to
voted
confuse
no. Delegate Munoz voted yes. So what would you like? What's your pleasure, Delegate Eric?
I like the color red a lot. I'll go with no.
All right. 3, 4, 5, 6, 7, 8, 9, 10.
Quote you on that the color of red is the color of no.
That, just to be clear, that was the bill that required prosecutors to talk with victims of sexually assaultive behavior.
Yes. 17-3. All right. Let's go to 323 then. There is an amendment. We share this with anybody? No, this is just us. Okay, the amendment is 503528. And council, that's Holly. Can you tell us what the amendment does and what the bill does with the amendment, please?
Sure. So the bill prohibits a landlord from using a lease or form of lease that contains a provision that limits the tenant's ability to summon or penalizes a tenant or another individual for summoning the assistance of law enforcement or emergency services. The bill also prohibits local governments from enacting laws that establish a threshold on requesting law enforcement or emergency services to visit a residential property. The amendments for the bill add under emergency services a mobile crisis team, adds additional local laws or ordinances that do not fall under the bill's provisions, and finally clarifies a local law or ordinance may not authorize a penalty against the tenant for the act of summoning law enforcement or emergency services.
I'm sorry, Holly, can you walk
Sure.
through that one more time, please?
Yeah, sure. So the bill has like two main parts. The first part of the bill prohibits the landlord from using a lease or a form of a lease containing a provision that limits the tenant's ability to summon or penalizes the tenant or another person for summoning the assistance of law enforcement or emergency services. The second part of the bill prohibits local governments from enacting laws that establish a threshold or benchmark for requesting law enforcement or emergency services to visit a residential property, which would result in the property being designated a nuisance and then penalize the person for summoning that assistance of the law enforcement or the emergency services. The amendments that are before us add mobile crisis team under the definition of emergency services and adds additional local laws or ordinances that do not fall under the bill's provisions. And then it also just clarifies that an ordinance may not authorize a penalty Right now it says a penalty. It's just a clarifying change.
All right, are there further questions about the amendment?
Move the amendment.
Motion for an amendment, to move the amendment, is there a second?
Second.
Second, all right, great. We'll have discussion on the amendments. Delegate Carden?
No,
No, you were getting ready, okay.
voting.
All in favor of the amendment, seeing no discussion, raise your hands. Bartlett, Carden, Fisher, Moon, Cham, Lopez, McComas, Davis, Williams, Shetty, Crutchfield, Jones, Howell, Anderson, Shoemaker, Tolles. Anybody opposed to the amendment? Grammar. All right. So we're on the bill as amended. Could I have a motion on the bill?
Move
Favorable.
Motion favorable in a second.
Second.
All right. We're on the bill as amended. Is there discussion related to this bill? Questions related to the bill as amended? All right, then seeing no discussion and having put everything in its appropriate stack here, the vice chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
No.
Bartlett,
Yes.
Carden.
Yes,
Carden? Okay.
yes. Sorry.
Conaway,
Yes.
Cox. Still in HGO. Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
No.
Howell,
Yes.
Rachel Jones. Rachel Jones. I heard yes. Lopez,
Yes.
McComas,
No.
Munoz,
No.
Shetty,
Yes.
Cham,
No.
Tolles,
Yes.
Williams.
Yes.
14-6. Favorable with amendments. Off it goes. Frederick County now, local bill 452, disposition of the county marriage ceremony fee.
Move favorable.
Is there an amendment?
Second.
There is not an amendment. There's a motion and a second for favorable. Is there discussion on House Bill 452? 452. For the record, it's $15 for the marriage fee, or the remainder of the marriage fee goes to Heritage Frederick. That will use the money related to the historical preservation there in Frederick County. So, all right. Motions for a favorable, and it was seconded. Don't see any discussion. The vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox, still in HGO. Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Chetty,
Yes.
Cham,
Yes.
Bowles,
Yes.
Williams,
Yes.
21. All right. These next couple are a couple bills that if people have questions about, we can take some questions if people want to hang on just for a brief moment because we just added them to the vote lists, as is what happens at this time of year. That is fine. And Delegate Williams will promise not to take it out on you, I think. I can't tell. She is smiling. Fine. All right, so we're going to go now. This is House Bill 518. There are no amendments. Could I have a motion?
Move favorable.
Is there a second?
Second.
All right. So this has to do with the maximum salary that a register of wills can receive. The actual amount that individual register of wills, I think, as we learned, it depends on the county. And so this just sets the maximum cap. It would raise it from 124,500 to 146,500. Delegate Williams, am I actually mostly right for a change?
Yes, you are actually 100% correct, Mr. Chair.
Oh, okay. Don't need to suck up that much. All right, that's fine. Are there questions? I see the vice chair. Let's start with the vice chair.
Thank you, Mr. Chair. Can someone tell me when a register of wills is not registering wills, what they otherwise might be doing in life? What's the comparable profession for one who registers wills?
It's like the
Estate planning, trust, estates.
Well, it'll probably be the clerk of the court. I mean, when they're not registering wills, they're administering, processing the paperwork for the probate of estates. I know in my county, they also have a depository where people can file their wills ahead of time for safe storage. They also do educational programs. I know in Prince George's County, all throughout the county, to educate people about the various services that the Register of Wills offers to the general public.
Do you need to be a lawyer to do that?
No, you do not need to be an attorney to be the Register of Wills.
Say that it's interesting. It seems like one of these very administrative offices that sometimes I wonder, as they are all there in the courthouse, why we elect this person. With no offense to any of the registers of wills who are out there, many of whom, all of whom are wonderful people. I just kind of wonder, it is a bit of an administrative office.
Mr. Chair, oh, sorry.
I'm sorry, go ahead, Vice Chair, and then I thought I saw Delegate.
Well, I was just going to piggyback on that with a follow-up, which is, if someone can tell me, Mr. Chair raised an interesting question about it being an elected office, but why, does anyone know why it's a partisan elected office?
You apparently just took Delegate Shoemaker's question and he's very upset.
No. I got another, I've got a follow-up.
All right, let's go to Delegate Shoemaker's follow-up question. And I don't think any of us know the answer to the Vice Chair's question, but go ahead. Delegate Shoemaker.
I'm perfectly fine with it being a partisan elected office, by the way, but in any event, what I can tell you, Mr. Vice Chair, is that very little of the Register of Wills job is registering wills. Most of it is the day-to-day ministerial stuff of running the Register of Wills office and acting as essentially clerk of the court for the orphans court and that sort of thing. They do a lot of work. I deal with them regularly, and I can tell you that.
Delegate Arakan.
Yeah, I'll just speak up real quick for the election process. I mean, I think traditionally your will was important to you, right? And it controls a lot of, your children's future can sometimes be wrapped up in there. So, I think the more elected offices we have, the better, really. Because who wants to have an administration and like bureaucrats controlling their money after they die? I certainly don't. I'd rather somebody that at least my kids could fire in the next election cycle. So
if they happen to live in the jurisdiction where, you happen to, yeah, okay. And it's at this point that I have gone completely down the rabbit hole. Delegate Cardin.
Thank you, Mr. Chair. Just a quick comment. So I happen to agree with Delegate Moon that there's no reason. I don't think the Register of Wills, which I considered actually running for, should be an elected office. I think it should be an administrative office. It is an administrative office. Certainly shouldn't be partisan. There's no partisanship in being the clerk of the probate court, which is essentially what you are. You are managing all of that stuff, and I would say, look, we're gonna pass this bill, but like raising when we are dealing with some of the crises that we're dealing with, giving people who elected people a raise from 124,000 to 146. I know that's not what all their salaries are, but that's what it looks like when we're passing it. That seems to be just a huge jump that we don't see anywhere else in the world, except maybe at like Google. So, you know, it just, you know, I happen to really like our Register of Wills. She's a former assistant AG. I'm just saying that, you know, there's a lot more to discuss here than partisan elections. So.
Well, only thing I'll add is that it's in the Constitution of our state. So there's that. And so, you know, they haven't had a raise in a number of years.
Their salary is not in the Constitution. I think that their elected officers is in the Constitution. Yes,
that is correct. The salary piece is not, but the elected office piece is in the Constitution.
But I mean, 124,000 is I mean, that is still a very, very, very reasonable salary. I'm just gonna say that.
And no one opposed the bill. I don't think we had any opposition to testify.
I don't think anyone opposed the bill either. I may have a question. Well, let me go to Delegate McComas, and I suspect I know why Delegate Fisher was going to show up there, but I need her to hang on just for a moment. Delegate McComas.
Yeah, I would say if everybody's kind of wondering whether it's too high, too low, and maybe we should just move on. I've got to hit the road here because I'm still in Bel Air. So I hope we're going to end at 4:30 at the least.
All right, move the previous question.
All right. So hang on a second. So we're all right. Well, I understand that. I think what we're going to do is we're going to do this bill 519, and then we're going to just walk through 559, and then I think we're going to run out of time at that point. I think we're going to hit it exactly right, and then we'll pick up from where we stop the next day, or it's tomorrow. That is the next day. Okay. All right. There's a motion for a favorable, and we will take a roll call. The vice chair.
Yes.
Shoemaker.
Yes.
Anderson.
I didn't really hear what the vice chair, did he say pass or yes?
He said yes.
Oh, all right. Well, I'm going with the vice chair. Yes.
Erican.
No.
Bartlett.
Yes.
Carden.
Say it slow.
I feel bad for McComas. I'm taking so much time. Yeah, why not? I mean,
Conaway.
Excuse.
That's true. Cox. Is he back? He's not back. Crutchfield.
Yes.
Davis.
Yes.
Juanica Fisher.
Yes, they picked a good bill sponsor.
Grammer.
Can I explain my vote, Mr. Chair?
Sure.
So I don't come from a family where many people make $108,000. And from the testimony on this bill, they said the average salary was $108,000. We're gonna jack up the maximums on these salaries, which is going to drag the average salary up. If you ask the average member of the public, I think they'd say $108,000 is pretty okay. So I'm going to vote no on this one, respectfully.
Thank you. Howell.
Yes.
Rachel Jones.
Yes.
Lopez.
Yes.
McComas.
Oops. No.
Okay. Munoz.
No.
Shetty.
Yes.
Cham.
No, but I still like the bill sponsors.
Tolles.
Yes.
Williams.
Yes, and to explain my vote, Mr. Chair, the increase would still have our Register of Wills making less than their counterparts in DC and in Virginia.
All right. That's 14-5. That bill is adopted. 421, I am sensitive, Delegate McComas, to what you have said, and I have taken the Harbor Tunnel many times during rush hour. We'll do the best we can here. 519, there are no amendments. This also raises the cap that exists for the county clerks or for the clerks of court. If I'm not mistaken, again, Delegate Williams, and it goes up the same amount, well, about the same amount. No, it goes up the same as the Register of Wills from 124.5 to 146.5. Is that correct?
That is correct. And again, this would also put us still with the increase less than their counterparts in DC and in Virginia, which I think in DC they make 180. And it's more as well in the state of Virginia.
And do you know by any chance, Delegate Williams, how many people work in the clerk's office, say in Prince George's County?
Oh my God, there's hundreds of employees that work in the clerk's office in Prince George's County. I'm sure the same is true for Montgomery County as well as Baltimore City. They manage hundreds of employees. They do yeoman's work in terms of processing all of our court filings, especially during this pandemic, having to get through all of that. And yeah.
All right. Can I have a motion, please?
Move
Favorable.
Motion for favorable in a second. All right. Is there further discussion on this bill? Maybe understanding that some of the previous comments might also be incorporated here from 518 to 519. All right. Seeing none, we'll do a roll call. The Vice Chair.
Yeah.
Shoemaker.
Yes.
Level of enthusiasm for the Vice Chair is truly awe-inspiring. Anderson.
When's the filing deadline for this office?
Anderson.
Yes. Yeah.
Erican.
No.
That you're against Anderson for Clerk of Courts, or you're okay? Bartlett.
You get a raise and you get a raise. Yes.
Carden.
I'm thinking there's gonna be a lot of people running for clerk of the court. Yes. $150,000.
Conaway.
Excuse.
Yep. Cox, still in HGO. I think he's still in HGO. Crutchfield.
Yes.
Davis.
Yes.
Juanita Fisher.
Yes.
Grammer.
No.
Howell.
Yes.
Jones.
Yes.
Lopez.
Yes.
McComas.
No.
Munoz.
No.
Shetty.
Yes.
Cham.
No.
Tolles.
Yes, Mr. Chair, can I explain my vote?
Yes.
I wanted to do it all at one time. Thank you. So I support this bill because I thought the clerk of the court just did the basic, give out, make sure that what is it, that all the stuff, with your house, filing fees and all that. But when I started to work on some legislation regarding licenses, particularly issues that, you've experienced as well, not you, but Baltimore City, the Baltimore region and Prince George's region with licenses, they do a lot more than what we are aware. So I think, it's important to make that publicly known that they do deserve, to be on par with some of their countywide counterparts that do just as much work. So for that reason, I'm voting yes. Said that 3 times, but thank you.
Delegate Williams.
Yes.
All right, 14-5, that's a favorable. All right, for those people who might be getting into cars to drive to Annapolis, we're not going to vote on anything else right now because we've got to finish by 4:45 anyway. And we're going to start the walking through of House Bill 559, which I suspect might take us to a point where we're going to need to stop anyway. Then we'll come back and pick it up tomorrow. So with that, this is House Bill 559. I don't believe there are amendments. And so we're not going to adopt the amendments today. But Delegate Juanita Fisher, if you wouldn't mind going through the amendments and what the bill does as amended, and then we'll see if anybody has any questions here.
Thanks, Mr. Chair. So this bill is a variation to our probation before judgment statute, in which a court may do it based on justifying a finding of guilt. with an agreement that the defendant accepts probation in exchange with the withholding of the guilt. The court may find the defendant on the underlying crime based on a justification of fact. With the amendment that's going to be offered, which is a sponsor amendment to this bill, it helps clarify not only that the consent of a defendant and the receipt of a probation before judgment doesn't change any of the terms of condition under law. So for example, if you were found guilty of a second-degree assault, your weapon would still be, if you had a weapon and a firearm, your firearm would still be taken away. And it helps with clarifications, especially for domestic violence crimes. Also, the amendment also helps just clarify language that all conditions would be the same in parallel with the other probation before judgment language. And that is what it does. I know for some individuals, they might say, well, this is going to totally get rid of the original PBJ language. For those that do for those that do enter like a plea of guilt, you need the original probation before judgment language for like a motion for reconsideration. So let's say a judge is not willing to give you a PBJ on your first time for something. After you do certain things, you would need the original PBJ for a motion for reconsideration. This PBJ wouldn't cover you in that realm. And that's basically the nuts and bolts along with the amended language, Mr. Chair. I can't hear you, Mr. Chair.
Sorry, it helps to not be muted. There are questions, so we'll go to Delegate Anderson first, then the Vice Chair.
Yeah, thank you, Mr. Chairman. I probably need a little clarification, Delegate Fisher. You indicated that one of the things the defendant has to do in order to accept the probation before judgment is to say that he or she accepts it.
Yes.
Okay, it's my understanding, though, that before a defendant can accept the probation before judgment, that defendant has to waive his or her right to a jury trial in district court, or waive a right to appeal.
That would be yes, that would be the same.
It's not the same.
Well, I mean, it would be within the bill that they would have to waive their right to a trial and appeal.
To a trial, jury trial, or to an appeal.
To accept it. Yes, Kurt. Yes, Delegate Anderson.
Okay. I mean, is that in your language in the bill now? Or because you're changing the language of the PBJ bill, are you saying that the language is he just has to accept it, or the language is that he's got to waive his right to, he has to understand he's waiving his right to a jury trial or to an appeal?
I believe, and I'll stepping it a little bit here, because this is, this was one of sort of the broader, what I would call due processy issues that I've had some questions about for some time. And it does, I believe, and I'm now struggling a little bit looking for the amendments and making sure that it didn't strike this. I don't think it does. On page 3 of the bill, you enter into the agreement beforehand, as I understand it, correct, Delegate Fisher?
Yes, Mr. Chair.
So it truly becomes a probation before judgment. That says the defendant accepts probation, the defendant knowingly and voluntarily waives in 2A under section Roman 3, the right to a trial, the right to appeal the probation judgment. So they have to explicitly waive those rights prior to even getting down the road with this. So that, I think that addresses your concern.
Yes.
Okay.
That's correct.
All right, thank you.
All right. Delegate, the Vice Chair, and then Delegate Cardin.
Thank you, Chair. Can you clarify, the sponsor clarify that with these changes, I understand the state's attorneys and everyone is supporting the bill now. Is that right?
I think they're neutral.
They're neutral. Okay.
I wouldn't use that word, but I would say there are state's attorneys like State's Attorney McCarthy and State's Attorney Braveway who support the bill. I think the overall state's attorneys are neutral.
So they don't have a position now.
I don't know if they don't have a position. From what I understand from hearing from several of them myself and engaging in some conversations with public defenders and state's attorneys this weekend, I think that a lot of the issues that they were concerned about have been addressed. There are still some who have some further concerns about it. I think that I can't speak for the State's Attorneys Association, but I think there's a little bit of a diversity of opinion there at the moment. I think it is fair to say that. Delegate Cardin.
Thank you, Mr. Chair. I think for my own edification and those of us who are really interested in this. So is somebody going to be able to advise the person about the two different options essentially that they're going to have? Because if you want to have like a sub curia held a motion to modify held, you're going to have to choose the probation before judgment that we have, or you have to choose to not accept this initial probation before judgment because you're going to want to, in my understanding, right? Is that or maybe that's actually not true because if you're offered it right from the start, then you would take it. But if you're not offered it, you would get the other probation. You would get what's in code now, because let's say you get a conviction, you hold it sub curia, you can't then get this one. You can only get the other one.
Exactly, because the thing is, you would be entering, let's bring ourselves to court. You would be entering this version of the PBJ with, you're discussing with the prosecutor, you're doing a plea agreement for it, right? If the judge is not willing to offer you a PBJ, right? Either version, right?
Right.
And you as the attorney, whether you're OPD or any regular defense attorney out there, when you do your motion for reconsideration, it's going to be on the original PBJ because there was already a finding of guilt. This is
right. I got that. But so getting back to my initial question is, there are some people that are going to benefit from this PBJ versus other people who it doesn't really matter to them. So for example, is it going to be the default that you're going to get this new probation for judgment, or is it going to be some kind of, discussion as to whether it's advantageous for you to not take it?
I will say, I think it's going to be determined case per case, client per client, what folks in courtrooms are going to want to do and what's the best, advance.
Is there going to be is there going to be some incentive that a state's attorney is going to give to not take the new PBJ but to take the old? I mean, I'm trying to figure out why it just wouldn't become the default unless you somehow you're putting a motion to modify sub curia, and then when it comes back and you did everything you needed to, therefore the judge is going to offer you the PBJ, but it's already after you were found guilty.
I mean, I can't speak for the mentality of individual state's attorneys in different offices. Because I just would feel uncomfortable speaking to that. I think it's going to really depend on each case. And I think for not some people are pro se, but for most folks that are in court with either the public defender, right, which you would get usually, or a private attorney, I think it's going to depend on what's going on with their case. And you know how it is for us. Sometimes it depends what judge and what prosecutor you pull that day. You might want to make a deal that day. You know what I mean? Or you might, everything is very live with cases. So I can't really speak to what people will do. I think this is an option that's going to be available to all Marylanders.
Right. And again, just going back to what the chair just said, you in open court, you usually have to waive your right to an appeal when you accept a PBJ. Now, what's going to happen is there going to be some sort of advice of rights written thing that you already know about before you even go in, or how? I guess we'll figure that out as we go. But
I think I honestly, I don't know if Mr. Chair wanted to comment, but I would think it will happen in normal course, Delegate Cardin, because you're going to be submitting to it under oath, and the same way our advice of rights has formed over time. I think, if you look on page 3 of the bill, I think defendants are going to accept the terms, and the judge is going to inquire if they accepted it before they entered this version of the PBJ.
I love it. Thank you very much. I'm looking forward to voting for it.
Well, and let me go, and I see Delegate Crutchfield with a question next, and then the Vice Chair. I guess the way that I read it, and look, just in open disclosure, I've had questions about how this works, again, from a due process question. And one of the questions the Attorney General raised was, how do you put somebody on probation without having found them guilty? And I think that this, to some degree, addresses that issue by, to a degree, baking into the PBJ statute. It's not really, I get, Delegate Fisher, where you're saying that this builds sort of an alternative way forward. I read it, though, as this is kind of redefining the way that a PBJ is done in the first place. I kind of look at it that way. And I think that what'll end up happening is you'll have judges who take the plea, who take pleas, and if, you know, the both sides will put what they believe the plea to be on the record. And if they think that a PBJ is possible, you might have a judge just sort of stop short and say, okay, I'm not going to find you guilty, but I am going to find that there are facts justifying a finding of guilt. They'll stop. And I mean, they're going to have already done in the litany, they're going to have given up their right to a jury trial, given up the right to all of those things anyway. So I kind of feel like, I don't know that this is a separate process. I think it's sort of changing the existing process a little bit to allow for someone to truly get a probation prior to the time that they get a judgment. And if I've made sense, tell me, but that's at least the way that I'm reading it. Delegate Fisher.
Thank you.
Yes, that makes sense. I didn't know you wanted me or Cardin. I
No.
agree. And
Okay.
I think you know, at least in my courtroom experience, I also think, Delegate Cardin, for your first question, I think if there's any question or issue, I'm sure both counsel will approach the bench and clarify where they're going. And then I think the judge will look at it and say, as Mr. Chair has said, there's a justification of fact based on the facts that have been presented. And very similar to if there was like a proffer read.
Right. I mean, and if the judge decides they're not going to, if they hear everything and they decide, okay, I don't believe a PBJ is appropriate here, and I gave some indication that I was going to do PBJ, they can just withdraw the plea. They can withdraw the plea, they can go to trial and do everything else they want to do. They don't have to, they are not then permanently locked into the agreement prior to this taking place. But I feel like I talked too much. Let's go to Delegate Crutchfield, please.
Thank you, Mr. Chair, and thank you, Delegate Fisher, for this legislation. Just a really quick question, just curiosity. What was the feedback, if any, from the Montgomery County State's Attorney, John McCarthy, on this legislation?
He was very supportive and came and testified for the legislation.
Thank you.
All right. Are there, I feel like we've kind of walked through this. We're gonna, I had intended to vote this bill tomorrow, and that is still my intention. This is basically to give fair warning that if anybody has any amendments, we'd ask you to please submit the amendments to the committee office by, let's say, noon tomorrow. We do have bill hearings tomorrow, so we'll ask for them by noon so that we can get them out to everybody. Are there further questions for the sponsor or for anybody else with regard to this legislation?
And Mr. Chair, you have the amendment, correct?
Yeah, I have the amendment. I'm not going to do anything with it today. I think we're just going to, because I know a couple members had to jump off to get in the car and start going to Annapolis. So with that, I think we'll just leave it right there. There are people who are obviously still at home. They need to get here for the 6 o'clock session tonight. We do have 10 o'clock on the floor tomorrow. Our intent is to have bill hearings tomorrow at 1 o'clock. There are 3 bill hearings with, I think, about 30 to 40 witnesses.
You're muted.
The criminal law, yeah, that's weird. The criminal law subcommittee will be meeting at 2:30 tomorrow after bill hearings. And then we will have voting at some point after that. My suspicion is, let's just, for right now, until it all comes crashing down in tears, we'll vote tomorrow at 4. But we'll see how we're doing with time with that. All right, so that has been, those are the bills for today. We will come back and continue on the rest of the voting list tomorrow. It's possible that further bills will be added tomorrow, and it is likely we will be voting on Wednesday as well. So if you don't see it for tomorrow, just hang on, we might be getting to it. All right, that's been the House Judiciary Committee on Pi Day. And we thank you all very much, and we will see you tomorrow.